Have you ever been subpoenaed, in other words, summoned to appear in court? Are you wondering what to do now? Hi, I'm Simon and I'm an attorney. If you've been subpoenaed to give evidence in a trial, you may be anxious. As a lawyer, the inside of a magistrate's court and a high court are familiar territory for me, but I know that for most people, a courtroom is a scary place. It may help to realize that the role of a witness is critical in our justice system. In serious criminal cases, witness testimony can help convict a criminal or acquit an innocent person wrongfully charged. Subpoenas are also common in civil cases such as divorce, child custody, personal injury, and commercial law. A subpoena is a Latin word which means under penalty, and it is simply what we call the method used to summon a witness to court. In South African law, there are two types of subpoena: subpoena ad testacundum and subpoena ducis tecum. Subpoena ad testacundum requires you to testify in a court case. For example, you may have witnessed a pedestrian being struck by a moving vehicle that ignored a red traffic light. You may be called to give evidence at the driver's trial for negligent driving. You're simply required to tell the court what you saw in your own words. Taking the witness stand can feel daunting, but remember, you are not on trial. Your testimony will help the judge determine what happened and the guilt or innocence of the defendant. If you have been served with a subpoena ducis tecum, you are required to bring certain items with you for inspection by the court. Ducis tecum means you shall bring with you. You may be requested to provide documents such as insurance records, medical records, bank or income statements, etc. But photographs, cell phones, and storage information devices may also be subpoenaed. Often, if the subpoena requests documents or data, you do not have to appear in court. You only have to provide the subpoenaed information by the specified date. A subpoena is issued by the clerk of the court on behalf of someone, usually an attorney, who needs your evidence as a witness in their case. They could be acting on behalf of the prosecution or defense in a criminal case. In a civil case, they may represent the plaintiff, the person bringing the action, or the defendant. Issuing and serving a subpoena are two different processes. An attorney cannot serve a subpoena. This can only be done by a police officer or the sheriff. The attorney requesting your evidence must provide all the details of the matter at hand, the parties involved, and your home or work address, which is included in the subpoena. It is then stamped as approved by the registrar of the court and either taken to your nearest police station or to the sheriff in your jurisdiction. The subpoena must be served in person. It cannot be posted through your letterbox or emailed to you. If you are served with a subpoena, you must sign it after it has been thoroughly explained to you. The signed subpoena is then returned to the attorney requesting your evidence. You are now legally obliged to attend court on the date given or provide the documents requested. Certain exemptions exist for individuals such as diplomats, consular officials, judges, and parliamentarians. The Diplomatic Immunities and Privileges Act of 2001 provides immunity for diplomats, meaning they do not have to appear as witnesses. Judges are granted protection against subpoenas without the consent of the court to ensure the judiciary's independence is maintained. In some cases, an ordinary member of the public may be exempted from the obligations of a subpoena. The Witness Protection Act 112 of 1998 makes provision for civil proceedings involving protected persons to protect the identity of someone under witness protection. If you are unable to attend the date of the court case, for example, if you are going to be overseas or having a medical procedure, you must write to the court and explain your reasons. In the absence of extenuating circumstances, I advise you to shift any other commitments to ensure you are free to attend court. If you refuse to attend, you may be held in contempt of court and a warrant could be issued for your arrest. You could wind up with a fine or even imprisonment. A subpoena is not something to ignore. Our legal system aims to balance the need for truth with the protection of individuals' rights, ensuring a fair and just legal process. If you are subpoenaed, try to look on it as an opportunity to play your part in the pursuit of justice in a fair and democratic society. The subpoena should state clearly what you are required to do or provide. However, if you have any questions or concerns, I'm happy to advise you. Give me a call or send me a WhatsApp on the number below.